Rob and I both, our firms are uniquely focused on estate planning, and when we were preparing for this presentation, we did a little bit of math and uncovered that we've probably combined done about 4,000 initial meetings. That lets you know how old we are in our career, right? So today I want you to take a moment to reflect as we get started. I think that the initial meeting deserves the utmost respect and the utmost intentionality. When you're meeting with a client, you're going to find out who they are, who they love, what they're concerned about. At the front of your outline, I put a quote that Dan Holbrook shared with our SEFI class, and I wanted to share it with you all. It's trust and estate lawyers should continue to take immense pride in the work that they do. The trust and estate field is the one branch of the legal profession that specializes in love. You help people build, maintain, and protect families. So what a privilege it is for us to be invited into these intimate parts of their lives. This is such a privilege for us. So let's get into our 9 holes, because like golf, an estate plan, it can be won or lost pretty early in the play, right? So what happens in that first hour is really critical. So Rob and I are going to walk you through a lot of different first off, starting with the purpose of the initial meeting. If you think about the initial meeting, that really is the highest leverage hour of your engagement. What are you trying to do in that meeting? You're trying to establish attorney-client privilege, define the scope, this is going to drive the accuracy of how you draft your documents, often determines if the client hires you, right? So your objective in that meeting is not just identifying what documents you're going to do. You need to leave the meeting understanding the client, understanding the family system, the assets, how all the assets are going to pass, the reasons behind the client's decisions. And one thing that we really want to press upon you, that we're not trying to tell you to have a scripted meeting. We're trying to impose upon you that this should be a roadmap. You really want to go into the meeting knowing where you're going to take the meeting. One thing I wish I knew as a younger attorney is you have to lead the meeting. I think early in my career, I would let the client lead the meeting. And I think one thing I've learned, and one reason Rob and I are really excited to dive into this presentation with you today, is because we really want to encourage you to lead the meeting. The client is going to feel more confident in you and your process if you lead the meeting. So when does this start? When we talk about the initial meeting, when does that start? It really starts when someone calls your office. So when someone calls your office, I asked our client coordinator, I said, Rob and I are presenting on an initial meeting and making sure it's effective and trying to help other attorneys. What if I brought one piece of advice from you, what could I tell the attorneys in the room? And she said, your person who is the front line for these calls should have a deep concern for others. Think about it. Sometimes when that person's calling in, this is the worst day of their life. They've found out they have a diagnosis, or they are estranged from a child, so they're really wanting to come in and talk about their estate plan. So have a lot of patience when someone calls in, and remember that this is an area of their life that, although we are doing this every day and it's something that can start to feel transactional, you need to remember the human element and how human this is. So we try to disarm, when clients call, we want to disarm them and explain the most important thing that we're going to do next is send them an intake form. So Rob, he's going to talk about the information he requests for the meeting next, but whenever our client coordinator calls to send the intake form, we like to remove the pressure. You're going to get this over email. We want to explain the process so they feel confident. What's next? You're going to get an intake form. You're going to get it through email, or if you need it mailed, fill this out. This is going to help us be successful. You want your frontline staff to be taking notes. You want them to, if the person on the call has mentioned they have a diagnosis, make sure they're taking notes of this. If the person on the call has talked about a divorce or a relocation, make sure they're capturing as much information as possible for you, and respond promptly and consistently. And we always ask, how did you get to our office? So Rob, what are you requesting before the meeting?
As much information as we can get. But for anybody who's done this for a while, you know that is a balancing act. If you request everything. A lot of clients, especially clients who are timid, they're going to freeze up. They're going to be hesitant to provide you anything. We, at our firm, we do an electronic intake questionnaire, and we tried to balance what we've requested. One, we want basic client information. We want full legal names. We want contact info. We want to know who their advisors are. We want to know who referred them. We work with a lot of different advisors, and I know you guys do too, and often those advisors have certain ways they do things, certain things they focus on, certain client types. That can tell us who we're about to deal with. We want to know about their kids. Are these their kids together? Are they minors? Are they adults? Are there priors from prior relationships? Are there mental illnesses? Are there substance abuse issues, gambling problems, supplemental needs issues? We want to identify that on the front end if possible. In our questionnaire, if it's a true initial estate planning consultation, we request that they think about basic fiduciary appointments before they come in to see us. Think about who might be appropriate to serve in a guardianship role or an executor or trustee role as a medical power of appointment. That way, when they come in, they're not just giving you answers from the cuff. They've hopefully put a little bit of thought into it. If there are existing estate planning documents, if they've done prior planning, we want to see that. Is there an existing will? Have they done powers? Were those powers done with their existing will, or was there some other transaction maybe that prompted them to get those powers done separately? Are there existing trusts out there? Are they revocable? Are they irrevocable? Were they established in a different state? All that information tells us something about who we're dealing with and where we might want to go with it. If they do provide us existing documents, how do those existing documents vary from the information they provided us in that intake form? Have they, 5 years ago done some planning, and today, when we look at the intake form, have they removed their daughter as their fiduciary? That's going to give us an idea about where we might be going in this meeting. Very, very helpful. Assets. If at all possible, we love to know what their asset holdings are. Obviously, for tax purposes, we want to make sure if we have the ability to put a structure in place to minimize what they might pay, that's a good thing. If we're dealing with blended families, or we have specific assets, we want to go to specific people, titling, beneficiary designations, all of that stuff matters. Also, if they provide us existing documents and they think certain assets are titled a certain way, that's not always the case, and we want to confirm that. Let's look at that entity agreement. Let's look at that trust, and if there's real estate out there, let's take a quick look to make sure that it actually owns the property. Old life insurance trust. We see those with some frequency, and it's not uncommon, at least for us, to see this great trust, but lo and behold, that policy that was purchased 25 years ago wasn't purchased by the trust. It was purchased by the individual. We want to try to identify that on the front end. Are there non-traditional assets out there we need to consider? Crypto. Here in Nashville, intellectual property, right? Do we have copyrights? Do we have IP we need to take consideration of? If we're dealing with a high net worth family, or we're dealing with a surviving spouse, have there been gift tax returns filed in the past? Have there been estate tax returns in the past filed? Do we need to consider portability? This is all information we love to have on the front end. If they are working with an advisor, especially an advisor we have experience with, and I get that intake form or my staff reviews it, and we see some of these issues out there, don't be afraid to reach out to that financial advisor. Call that CPA. A quick 5-10 minute call can tell you everything you need to know about a specific situation that needs to be addressed with their assets or with their family circumstance. Marital dissolution agreements. If somebody's coming in because they are now divorced or they're now remarrying after a prior marriage, want to make sure if there's an MDA out there that has requirements for that X, that we are in abidance with those requirements. So MDAs are also another item that we typically want to look at. Oh, QSBS stock. Dealing with a lot of entrepreneurs who are trying to to grow a business. If they have qualified small business stock, we want to be aware of that because there could be certain tax planning techniques that allow us to maximize that QSBS exemption. What did I miss?
Well, you covered a lot. That's why the intake form is so important. You're going to capture so much information on that intake form. And I want to talk a second about some blind spots on the intake form that you may want to ask intentionally in the meeting. So like Rob said, you're going to want to look at existing trust. I ask clients now on my intake form, do you have a power of appointment? Well, don't just trust, if they say yes or no, don't necessarily trust that because they might not really understand what that means. So you will want to in that meeting, are you a beneficiary of a trust? Okay. How long have you been a beneficiary? Have you looked at the trust lately? I've actually helped uncover for a lot of clients that they actually have a power of appointment. So that's a blind spot that if you just simply ask it on the intake form might not translate in the first meeting. Also, you want to ask them, do they have out-of-state property, foreign property, were they a resident of a community property state and then they've moved here. You'll want to be careful when you're setting up trust and moving assets that you don't mess anything up if they were in a community property state. Also, like Rob said, we want to see, do they have business entities? We want to see your corporate documents. That's very important. Firearms as well, if they are going to require any specialized planning. Also, one thing I have started stressing in my intake that I used to not stress is I'm asking about liabilities now. One thing I wanted to mention, I feel like is very important for you all in the room, I'm sure you do probate as well, but has anyone had a claim from the Small Business Administration yet? I recently had one in my estate, so I'm being more intentional with my estate planning clients that have businesses because this was new for me and I really went on a deep dive trying to figure out what in the world is going on here because I've never seen it in 12 years of practice. But basically in the cover letter to my client it says, as you may know, the federal priority statutes place liability upon the personal representative of the estate. They have a 6-year statute of limitations. I feel like this is huge. So I am now asking my clients, what type of loans do you have? And then on the estate side, I'm also asking that because this claim came 4 years after date of death. They are not subject to our 1-year creditor statute of limitations. So this is something that needs to be on everyone's radar if you're working with clients that have businesses that may have these loans, because it's fully possible that the surviving spouse, if she had nothing to do with the business, she wouldn't know about this loan and then it comes about later. So that's very important. Just if you're following along in the outline, an intake blind spot, you want to ask client, what type of debts do you have? Next, if you're a whole number 3, if you want to go to that, setting the table, we're going to talk about how do you prepare for the meeting. Rob, what are you doing to meeting format? Who are you putting in the room? What are you doing pre-meeting? Rob's going to go over this, and then we're really going to get into the fun part where we talk about the actual meeting. So Rob, prep us for the meeting before we get into the meeting.
I think the preparation is kind of fun, actually. We are service providers. We want to make it as easy as possible to serve our clients. And part of that is being accessible. This day and age, in addition to meeting in person with clients, we are very frequently meeting virtually with clients, new clients, prospective new clients. We're also, on occasion, if need be, having initial phone conferences with clients. And there's pros and cons with each of those approaches. For me, from my perspective, if I can sit across the table from somebody, it's going to be the easiest way for me to build rapport with that client, to identify, what might be driving them, to maybe get some nuance as to what their family dynamic is between spouses. Is there a kid in the room? Is there an advisor in the room who can add to that? Also, if it's in person, the client is vested. They're having to take a little time out of their day to come see you. They're going to take it more serious. You're not going to hear the news blaring in the background or the dog barking. They can be more focused on you. But we live in a growing city and it's not easy always to get to our office. So we are regularly meeting virtually with folks, which I think is great. We have the technology to do that. It allows us to work with a broader client base. But you have to be careful. It's not as personal. You have to go out of your way to help try to build that rapport on the front end, which Ashley's going to go into more in more depth here in a minute. Also, there's risk exposure. You maybe can't see that spouse sitting outside the camera, or that child who's nudging dad to say this or say that. Also, we have all these AI note-taking apps that are out there. We have to be careful. I personally don't allow them in our meetings, but that doesn't mean you're not being recorded. Granola, that app, it runs and it doesn't even come up on your Teams or your Zoom. So you always have to presume, at least the way I feel, you have to presume that even if you don't see a note-taking app in that virtual, that you are being recorded. So you have to be careful there. Telephone calls are the most convenient way, obviously. Certain clients, especially if we're doing routine planning where we're providing for traditional husband-wife scenario, 3 kids together, we're not making any unnatural distributions, that may be an appropriate forum to have that initial conversation. But we certainly want to lay eyes on that client and walk them through certain questions when we have the signing meeting or if we have a follow-up meeting. But you've got to decide how best to meet and interact with your clients in your practice. Staffing the meeting. When we get intake information, one huge benefit of having more information is we can decide who needs to be in the seat. Different firms have different approaches. Our approach generally is to have 2 attorneys in every initial meeting. We want a more senior attorney, and typically we want what I would call a lead or a primary attorney who's going to be doing more of the heavy lifting on the drafting end and some of the basic correspondence with clients. But if we have a client that we've identified having a specific issue, maybe they're a high net worth family, maybe there's a special needs issue, maybe there's business interests we need to address, we want to, if possible, make sure we've got the right resource in there. We've got that attorney who has experience in that field at the table to help that client so we can be more effective during that meeting. A lot of firms don't go with the 2-attorney approach, and that's okay. I think if you're meeting on your own with clients, you just have to make extra effort to make clear notes and make sure you're catching everything. One thing I love about having 2 attorneys is, if you haven't figured it out yet, I'm not terribly articulate. I'm not always the best at getting a certain point across, but I've got some other folks in our firm who are way smarter than I am and can pick up on that and chime in to make sure that we're doing a better, more clear job of explaining things to clients. So if you're on your own in those meetings, you have to be on top of that. So pre-meeting, as I mentioned, we look several days ahead of the initial meeting to see if we have intake materials, who's going to be a good fit for that meeting, and we staff that meeting appropriately. Prior to that meeting, our 2 attorneys are reviewing all that information. We are looking to see what asset info is out there. Are there existing docs? Are there concerns pertaining to those existing docs? On the intake questions, have they expressed concerns that need to be addressed? We typically summarize that information in a form, in our format, so when we're going through a meeting, we know exactly where to look when a question comes up. Also, I found if you have a personal intake form or custom form that you use to take into those meetings and you're prepared, it shows the client that you put some thought and effort into this. It brings them comfort. They're dealing with somebody who's taken a few minutes to know who they are. But just like getting information, preparing for a meeting is a double-edged sword because we haven't been engaged yet. I don't want to spend 5 hours reviewing existing documents and balance sheets and prior tax returns if ultimately, maybe it's not going to be a good fit. So, got to watch that as well. Got to figure out how much effort to put into it. AI. We use Copilot, the enterprise version. We're told our information is not going out into the rest of the world. For those of you who are using Copilot or a similar type system, reviewing that intake form, reviewing those estate planning documents, it's huge. It's going to help save time. It's going to pick up things that you might not get in a 20-minute flip through the documents. So I ought to consider that. I think that's, for me, I've done this a lot. Looking at who referred the business, looking at the balance sheet, looking at existing documents, And then, with who is in that meeting with me, having a quick debrief over the intake materials before we go in there. So me and my colleagues are on the same page when we start that meeting, making sure we know what potentially we need to touch on during that meeting. That for me is how we get started before we go into the actual client meeting. But then, all the real fun apparently starts, right?
You ready to go into the meeting?
That's right.
Okay, I'm going to start off with some things that are not really legal in nature. I want to talk about some human elements. When you walk in the room, eye contact, immediately. Stand, shake their hand, and tell them thank you for being there. They could go anywhere. There are a lot of estate planners. Thank them for being in your office. Make eye contact. Don't cross your arms. That just body language, usually you're more open. I try not to ever cross my arms during a meeting. You don't want to appear closed off. Also, never say nice to meet you. It has burned me before. So I always say nice to see you. Always say, train yourself, nice to see you. Never nice to meet you. Even if you genuinely know you're meeting them for the first time, I think it builds better rapport and better relationship to nice to see you. It doesn't feel like you're starting from the ground up. So that's just a little pointer that might help you. And it doesn't feel good when someone says, oh, but don't you remember our kids were on the same t-ball team? So you always want to start off with the nice to see you. Also, if you have an anxious client, disarm them early. Tell them, I want to make this a joyful process. This is part of financial wellness. You will have clients who come in and just think, oh my goodness, I'm talking about death. So try to disarm them. Try to make them comfortable. I always tell them, this is the greatest gift you can give your family. So you start out the meeting warm. Your meeting should follow a sequence, this roadmap that we're talking about. You want to build rapport. So Rob and I have talked about how important that intake form is. So I've reviewed the intake form. If I see on the intake form, oh, your daughter lives in Pennsylvania. I was born in Pennsylvania. I try to look for some common ground with the client. Something so I'm not walking in the room and saying, how is the weather? How was your day? I try to avoid those little small talk questions because they just feel too mechanical. So I want to look for something. And you know what? You might not find anything, but if you see something, it's a nice way to set the stage and just start the meeting on some common ground, a way to get to know them. So when you're thinking about how you're going to guide the meeting, I like to come in the room and tell the client immediately, my goal for this meeting is to get enough information out of you so that I can prepare your estate planning documents. And I can imagine that you are sitting there right now with lots of questions, but just trust me, I'm going to walk you through this process. And by the end of the process, you're probably going to look at me and say, oh, wow, I don't have as many questions as I thought, because I'm telling them where we're going to go, and then I'm going to lead them down the roadmap. And Rob and I are going to kind of talk more about how we go down this roadmap. But initially, you need to set the stage with the client. You have to take the lead in the meeting. If you don't take the lead, you're going to be talking about what happened at Christmas and how their daughter-in-law doesn't let them see the grandkids. And that is all very important information that we want to make note of. But you've got to lead the meeting. Your time is precious. Their time is precious. So you go in the meeting, you build the rapport, you tell them what's going to happen, and then you start to frame the session. You tell them what you're going to work on. You also observe, who's answering the questions, who's not answering the questions. You find out, maybe they start to tell you when you're having genuine conversation with them. I like to ask questions like, so, when was the last time you saw your daughter that's in Florida? And although that sounds like I'm trying to get to know them, I'm making mental notes of, oh, I haven't seen her in 5 years, or, oh, we see her every month, but my child that's in Oregon, we've not seen them in a while. So I'm asking these questions about the family that are very intentional. They might sound like I'm just getting to know the client, but I'm trying to be very intentional in the questions that I'm asking. So, Rob, I know you bring something into the meeting. So what are you bringing into the meeting to show them that you've prepared, and how are you clearing the deck?
Yeah, I want folks who have spent effort and time to provide us information to know that we've looked through it. We've come into this prepared for the meeting. So we're going to have a summary. We're going to have our intake forms. If they have existing documents, we're going to have what we believe pertinent to the meeting, print it out so the client knows we're there to talk business. Also, I want to clear the deck. I want to make sure, when people come to us, there's usually a reason, right? I don't get random calls from folks off the street who just all of a sudden willy-nilly want to do estate planning. There's some pressure point, whether that's a family issue, maybe it's just a parent nagging their kid to be responsible because they've just had a kid of their own. Maybe it's a financial advisor who's been pestering them for the last 10 years, but there's some reason they're there. Now, oftentimes when we prepared, if they provided us info, I can probably guess what that pressure point is. And I want to, when we get started, let them know, hey, we're going to be talking about kids and protecting kids. And if we have any issues with kids, we're going to talk through that in depth. Or if I maybe don't have a general idea as to, to what the pressure point is, I'm going to straight up ask the clients before we get going, are there any issues? Are there any concerns that you have that have brought you here today that you think we need to be aware of? And hopefully they will open up, and I'll let them know, absolutely we're going to go through that. We're going to get there, and we're going to talk in great depth about that. But before we get there, we're going to start slow. That's usually how we approach it in our office.
We both like to start with easy decisions first. We have very similar ways that we structure our first meeting, and we find it very effective. So you want to start them with confidence. So you want to get them making decisions that are easy. And one of the decisions that I like to start with, I tell them, okay, we're going to start out talking about power of attorneys. So Rob, I'm going to do an illustration with Rob. Rob, who do you want to name as your power of attorney?
My son, Jack.
Okay, who's alternate?
Well, not his wife. She would make Britney Spears blush, I'll tell you that.
Okay, let's start over. That was the bad example. Okay, we're going to start over, and I'm going to show you how an intentional attorney is going to do their power of attorney appointments. Okay, Rob, let's get into power of attorneys. Who would you like to name first as your power of attorney?
My favorite son, Jack.
Okay, why are you naming Jack?
Because he is responsible. He's on top of it, and okay. He's going to be the one there wiping the drool off my chin when I'm at the end.
Good. Okay, wonderful. So that was just a tiny illustration of your follow-up why. Just a follow-up on every fiduciary appointment. Why are you picking them? You want to ask these intentional questions that allow the client to explain, and then it's going to make your job easier as you flow through the planning meeting. So yes, we both like to start out with early, easy decisions, so client starts feeling confident, and then we move to the more dispositive provisions planning towards the end. Rob likes to start with, going straight to the kids before the spouse, but let me tell you, I have a little trick how I decide if I'm going to do kids first or spouse first. I will ask the client at this point in the meeting, I'll say, how did y'all meet? And then if they glowingly tell me this beautiful story that is just so nice to witness, then we'll start with spouses. But if it's kind of like, well, we met in a bar and here we are and, we're each other's fourth spouse, then okay, well, let's talk about how we might want to structure trust for children first. So I actually just use that in the middle of my meeting when I get to the point of dispositive provisions. It's another way to build rapport with the client, get to know them. And I actually love hearing those stories. And it's really neat when you've got an 80-year-old client, they look at each other and they think about, well, how did we meet? And they tell me this beautiful story, and it's just a fun peek into their life, and you really start to get to know them. So I like to use that question to build rapport, but also I decide where I'm going to go next. So I kind of get the sense, do we start talking about marital trust options? Do we start talking about, do you want to do a joint trust? We're just basically getting to the meat and potatoes of how their plan is going to be structured. So I really like to use that point to decide where I'm going next. But okay, Rob, you wanted to get into how you move through the dispositive provisions, right?
Sure.
Okay.
Yeah, I'm talking about kids. Are they responsible? Are they not responsible? Are there other concerns that we need to address? If they're minors, who might be appropriate to manage those assets? Are we talking high net worth planning where maybe GST, dynasty type trust planning makes sense? that to me is where I typically start, and maybe it's just my frame of reference. My wife, I know, we've been married a long time, and I love her to death, but she'd rather talk about our kids than me any day of the week. So maybe that's why I like to start with kids. But once we iron out kids, any other non-spousal beneficiaries, I'm typically transitioning to the spouses. And one caveat to that, obviously, is if we have clients who do not have children. That's a whole different animal. But when we're talking spouses, is this a blended family? Do we need to consider some form of bypass, credit shelter, marital trust planning to protect children from prior relationships? Are there tax considerations? Are there highly appreciated assets where maybe community property trust planning would be appropriate? That's usually the direction we go. I am old school. I grew up under the tutelage of Judge Hedrick, and our general approach was will-based planning. I still feel like that's the way to go, but a lot of clients who come in to see us today, they don't want to hear about it. They have been sold on revocable trust planning, and I found myself spending an hour explaining to them they don't need it. And I've gotten to the point oftentimes where maybe from a probate avoidance standpoint, from some sort of tax efficiency standpoint, in my view, trust may or may not be the right tool, but you just got to go with it, right? If that's what they want, as long as it's not going to in any way adversely affect what they're doing, maybe it does give them some added privacy, maybe it does add some administrative efficiency. You got to feel that out. Do we go trust? Do we go will-based planning? Oftentimes, even though I might want to go a different direction in my head, if I know the client is gung-ho on this, and I know it's not going to harm them in any way, we'll go in that direction. Yeah, I think that's for us. And then obviously more advanced planning techniques. Is there gift planning we need to consider for tax purposes? Are there asset protection issues? Are we dealing with folks who are in high-risk professions, developers, surgeons who want creditor protection on the forefront? We're going to have those conversations there as well. Yeah, I think that's at a high level how we would approach those dispositive provisions.
Well, Whole 5, asking better questions and issue spotting. So that your meeting's going to be more effective if you're asking good questions. What prompted you to be here? Questions like that will help you know if there is, family concerns going on. Clarifying questions. If a client says fair and equal, follow up with that. What do you mean by that? What does that look like? Also, we do a lot of consequence testing questions. Well, what happens if your child gets divorced? What happens if this person predeceases you? What if they have a creditor problem? What if they're disabled? So you can use lots of consequence testing questions. What do you want to do if? Also, values-based question. If I get stuck in a meeting, if they can't decide between a will-based plan and a trust-based plan, we'll take a step back. What's most important to you? Is privacy most important to you? Is avoiding probate most important to you? We have the most amazing probate judges in Tennessee. So avoiding probate is not always a chief concern. But like Rob, I'm not going to talk you out of a revocable trust, but I do go over with clients will-based plan versus trust-based plan. I try not to let that topic hijack the meeting because you can really get in the weeds there. You just need to guide them. Okay, you have out-of-state property. Let's go with the trust-based plan. You can use these questions to kind of guide where you're going. One thing I do in all of my meetings that I think is very important is I take a moment when I'm getting into how things pass. I take a moment to explain to clients how assets pass. Now this might seem, you might have sophisticated clients who understand this, but I've actually been surprised that, conceptually a lot of clients struggle with this. They think if they do a trust or a will, that covers, okay, if I do that, I'm fine, that covers what I want. I, early in the meeting, just say, let's talk about how assets pass. You understand that your 401k is not going to be controlled by the document that I prepare because you're going to have beneficiaries on there. Also, your life insurance, that passes outside of your plan if you have beneficiaries on there. Of course, we can, make it work with your plan and we can bring it through your plan if we need to, but it's very important that you give the client a little bit of education about how their assets pass. For example, I had a client, and I always, one thing Rob and I do, we want to look at deeds. I recently had a situation where a client sat in front of me and they had a couple $1 million farm in another state. And they said, oh yeah, that farm, we just finished Dad's probate. It's titled with me and my niece. And I said, well, I need to look at those deeds. And they weren't worried about it at all. I looked at the deed. Niece is 30 years younger, and the attorney set up a survivorship deed. And I was able to uncover for this family, millions of dollars are not going to come to your side of the family if we don't get this deed fixed. So never just trust what your client says. You've always got to look at things like that because it is so important. And now these clients think I'm the greatest person ever because I have saved millions of dollars for their family, and they are telling everyone that they need to double, triple check this type of stuff. Estate planning is not just going to get a will. Estate planning is looking at all these things in conjunction. So we have in your outline, if you're following along, we did put a little section in there, just say review existing documents. We put an appendix in there with proper will execution. I'm still unfortunately getting a lot of wills that aren't properly executed, and then we have to go search for affidavits. So just for new attorneys, I've put that in there as a reminder. Make sure your documents are properly executed. If you're reviewing a plan, make sure it's properly executed as well. Rob, when a client comes in with an existing plan, what type of issues are you looking for in that existing plan?
Yeah, we're looking at everything. Obviously, as you mentioned, we want to make sure they were properly executed. We want to look to see what jurisdiction they were executed in. Were they done outside the state of Tennessee? Is there some language here in this state that would be appropriate? Tax planning, in particular, cost basis planning. It's huge. I joke with our clients, if you've lived here for 2 weeks, you have immediately over $500,000 of appreciation in your home. For a happy married couple, utilizing a community property trust may be a great option to, if one spouse dies, to give the surviving spouse a lot of flexibility if they want to sell that asset or they want to downsize, or even if they don't, just giving them the ability to do that if their circumstances change is huge. Clients who own real estate in Tennessee, even if it's not their primary residence, even if they don't want to sell it, if it's a residential rental property or a commercial property, if instead of getting a half step up, they get a full step up in cost basis, going forward after the first step, they're going to be able to redepreciate that asset from that new cost basis, offsetting their rental income going forward. It's a potential huge benefit. Are there irrevocable trusts out there? Are we dealing with a surviving spouse who has a credit shelter or a bypass trust in place? Or are we dealing with just a standard irrev trust that came from a parent or a grandparent? We want to look at the terms of that trust to see if that client with their personal estate is underneath the exemption level, whether or not it makes sense for us to enter into some sort of modification of that irrevocable trust to, at that client's death, cause certain of those trust assets to actually be pulled into their estate, so when they ultimately do pass to residuary or remainder beneficiaries of the trust, they potentially get that step up. It's a big deal. And not just that, we get clients who come in with a rev trust and they think it just is what it is. And as most of you know, we, under certain circumstances here in Tennessee, have the ability to modify those trusts. One, for tax purposes. Two, if our successor fiduciary appointments don't make sense. Let's talk through that and see if we can clean that up before something happens. Circumstances change, and kids and grandkids, their circumstances might not be what they were when the trust was established. If we have a kid who's going through a divorce or has creditors or now has mental illness issues, now might be the time to address it, certainly before you're gone. Old funding clauses, if we're dealing with a trust that was established X number of years ago and we got the Tennessee bypass and we got the federal bypass, it may make sense to clean that up. The Secure 2.0, we want to update the IRA, the qualified IRA language typically within the instruments to make sure if we're going to name an IRA to the trust as beneficiary, that it's easy for us to, with a straight face, get the conduit treatment if that's what we're going for. Surviving spouses, if we have someone who's come in and they've somewhat frequently lost their spouse, we want to look to see if a portability return, a 706 was filed. If not, does it make sense to do so? Even if it maybe doesn't make sense to do so, we might want to, at least in writing, document to them, this is why you might do it, because we don't know what the laws are going to look like down the road, and if they do change or their financial circumstances change, we want to make sure that they've been advised of that. We've practiced defensively. When we're dealing with high net worth clients whose parents are still living, who maybe aren't as high net worth as their children, we oftentimes will mention to the clients, hey, they need to look at their existing documents, because if they want to benefit you, it probably, at least from a tax standpoint, doesn't make sense to, upon their death, leave assets to you outright. They need to be leaving assets to you in some form of a exempt trust. So you potentially have the right to use and benefit from those assets, but when you're dead and gone and they go downstream to your kids, they're not subject to estate or generation skipping transfer tax. Existing real estate, Tennessee, we got the Greenbelt issue. If we're doing any sort of transfers, we want to confirm if we're dealing with Greenbelt property. If they have rental properties, we're looking at STRP, short-term rental permitting, to make sure that if we're doing any sort of transfer, we're not going to muck up that permitting. You got the whole F&E FONSI exemption. There was a recent change in the statute. I'm still trying to get my head around it, but if we're transferring assets to or from LLCs or corporations, we want to make sure we're aware of the FONSI, the F&E issue. And as Ashley mentioned, we are wanting to make sure if there's out-of-state real estate, out-of-state mineral rights, that we're taking a close look at that as well. And as I mentioned earlier, MDAs, those marital dissolution agreements, are there alimony requirements? Are there child support requirements? Is it at an end of the term? Is it in forever, in futuro? We need to address that as well. So yeah, that's when I'm looking at existing documents. Those are issues that, at least in my mind, I'm trying to identify. Is that there, and if so, do we need to potentially address it with the client? But when it's all said and done, we got to wrap that meeting up. And the close, I think, is critical. You want to make sure that client is leaving with confidence and they know what's next, right, Ashley? You gonna walk us through that?
So at the end of the meeting, I like to recap what we've done, what we've went over, if we have what's outstanding, what are their concerns. One bit of advice I give to clients that I know not everyone agrees with this is I tell my clients, you don't have to share these documents with anyone. You don't have to give your kids a copy. And I think most people think they should share with their kids. I actually, because of some bad experiences where an adult has, my client has shared with their children and the kids didn't like it. They didn't like that they weren't the executor, or they didn't like that their share was in trust. And then it caused a rift in the family. So my standard advice is don't share this with anyone. Just tell them who your attorney is, where your documents are. These are things that you need to keep together. You do not, because it could change, right? These documents absolutely could change in the future. And you don't want to cause any family disharmony when documents can change, decisions that you've made can change. So I always recommend to clients, you don't have to show this to your children. And a lot of them, it's like a bulb goes off because I think they were just planning to share them with them. So it's at least worth having a discussion that, they don't have to share those documents. But of course, you want to make sure that you've set their expectations. You want to make sure that they understand the scope of the work, what you're doing, what comes next. Rob and I actually do it a little bit differently in how we close out, but I usually have my engagement letter there and done. They do it sent after the meeting, right? So, different attorneys, different firms can do things differently, but I think the most important part to round out Whole 6 before we get into complex family dynamics is we really just wanted you to think about, does the client know what's next? I actually schedule signing if it's appropriate and if we're moving forward. I like to go ahead and schedule a signing meeting. I've not always done that in my career, but I do that now, and clients really like it because it's not just they're waiting for, they don't know, I'll get it in 4 weeks, 6 weeks, when am I going to sign it? My schedule fills up quick, so I like to offer them the ability, would you like to go ahead and set our signing? If that's appropriate. Obviously, some people have complex plans and that's not appropriate. But if it's appropriate, that's something I started doing later in my career, and I really think it's been effective and efficient, and clients like it. So that's something we will do at that time. If it's appropriate, we will allow them the option to schedule the next meeting, and we will leave with a list of things to do. They will have to, they will have a certain list of things that they need to do, but we can have that next date that we're waiting for. Do you want to talk about, scope and what you put in writing, and then we'll get on to complex family dynamics?
Yeah, we have to move quick too.
Yeah,
what we do, in my view, it's an art form. It's not a science, and it's the practice of law. You never master it. You're always working, and we don't want to script typically. But when I'm closing out a meeting, there is, in my mind, a general script I want to follow as far as setting expectations. One, what are we doing? What are the deliverables? What are we providing the client? What does that timeline look like? We want to set expectations. Is it 3 weeks? Is it 4 weeks? Is it 2 months? I want to set an expectation that internally we can hopefully beat. I want to make sure we're notating that expectation, so if stuff comes up and you got to pivot, you can, before you hit that deadline, contact that client, let them know we're thinking about you. Unfortunately, we're not going to have your drafts to you by then, but we're going to push that goalpost back for you. I want to make sure that if we're working with other professionals, CPAs, wealth advisors, trust officers, that we have permission to communicate with those advisors and request information on correspondence.
I put that in my intake form. Do you?
I do not. In our engagement letter, we have that, but I also request that just verbally in the meeting. Maybe I should start doing that on the intake form. I want to set what the fee expectation is. Are we doing this on a flat fee basis? Is this hourly? If it's hourly, if at all possible, I usually want to give the client a range. When is payment expected? A lot of clients, they're apprehensive to talk with lawyers because they're scared the hourlies are going to go out of control. I want to, if possible, set that expectation. The first many years of my career, I did not frequently use engagement letters. It just wasn't the way I practiced. I have learned that an engagement letter, one, it sets the scope, but also, and for me more importantly, it also sets forth within the engagement letter what's not in scope. We don't do title work. We're not providing title insurance at our firm. We're not business managers. We're not filing tax returns. I want to make sure that if another professional that they're working with has a responsibility that doesn't get done, we're not having the finger pointed at us. Also, I think by sending a professional engagement letter, it lets the folks you're working with know that you're for real. You're a professional, and this is what we're going to be doing for you. And a little tip, we do all of our engagement letters, with few exception, by e-signature. We use Adobe e-sign, just because we're working in the PDF already. It's easy just to send it out. And we, if at all possible, send it out that day. We want that fresh, and we want that quote. If it's a flat rate quote, we want it front and center so the client sees it. And my engagement letter over the last 5 or 6 years has grown, and it's attached here for you to look at, and you'll see it's fairly exhaustive. I can probably count on one hand the number of clients who've ever pushed back on it. If you send it virtually or electronically, and you get the quote right, you spell their names right, the scope, the deliverables is where it needs to be. Typically, you're not going to have an issue getting that executed. If they don't execute it, or one client execute it and not the other, and we move forward, we will require them, when they sign their documents at execution, that they also sign that engagement letter. Also, joint representation. Want to have that conversation with clients, especially blended families. If this is a joint representation, you guys got to be on the same page. If not, you need separate counsel. That, I think, is important. And that is also, as you'll see in the engagement letter sample we provided, there's a blurb in there with the language we include there. So yeah, that's how I close the meetings. We historically have not requested clients schedule a follow-up to sign documents. We are trying to implement that with some success. For certain clients, it's very helpful. So that's, I think, something that definitely needs to be considered.
Since we're running out of time, I do think Rob and I could talk to you about this for hours, but I'm going to just kind of skip to my practice tips because those are what I like to walk away from CLEs with. So we're on Whole 6, Complex Family Dynamics. You can read through that, but I did want to make some notes. So if you do have a client who's wanting to treat their children unequally or disinherit a child, I will set the stage in that first meeting. We're going to meet multiple times if this is what you're going to do. I let them know, make that very, very clear. We're going to have multiple meetings if that is something that they truly want to accomplish. You also want to plant the seed. This document lives on forever with your children. So could it be appropriate to maybe give one child your IRA, let your plan look like you're treating the children equally, but then maybe with assets that are not going to flow through your trust or your will, could you structure it in a way so that, you're treating them unequally, but your documents that they're going to read look like they're being treated equally.
I would just add on unnatural distributions or allocations. This is a trick of the trade I learned from Judge Hedrick. When we execute those documents, we require our witnesses be licensed attorneys. If they're executing something that doesn't require a witness, we want to make sure that the prepared by is in the room and also the notary is an attorney who is signing that. That way, if there ever is an issue and we have to go in front of Judge Hedrick to explain why we think this happened in this way, we have attorneys who hopefully will do a good job at that.
Good point. And if you're in the room and you're worried about capacity, or you have someone, if they had to have a child come, I'll have the meeting, but I just clearly let them know, unfortunately, you're going to have to come back. You have to come back without your child. Your child cannot bring you if they're wanting to treat children unequally. Also, again, under the framing questions point, sometimes it just comes across, may I ask, do you mind if I ask, are you on any medication? Is there anything affecting your decision-making ability? You can ask those questions. Don't be afraid to ask those questions. It's very important to ask those questions. And then another tip that I like to do that is just something that you probably have thought about or you may not have thought about is if I have a client who wants to appoint a child as executor and they're out of state, or they have concerns about their executor's age, I will just say, why don't you appoint a corporate fiduciary behind that person? So if they can't serve, we have options. So that's always just a tip to be thinking about when you're drafting so that your documents withstand the test of time. Build in a lot of flexibility. And let's see, how are we doing? Okay, we've got 3 minutes, Rob. So what do we want to leave them with? If we could do the roadmap in one page, what would you leave them with?
Preparation. When that client contacts your office, that is their first impression of you, not when you walk in the conference room. We've got to make sure that we're being responsive, that whoever is answering those initial phone calls or responding to those email inquiries is doing so in a thoughtful manner. And I think just setting the expectation with the client during the meeting and making sure you're the one setting those expectations, not them, not their other advisors.
Yeah, absolutely. Remember, the meeting is won or lost before it starts. Preparation is key. I will still meet with clients, but if they don't have an intake form, I just let them know I can't do my job without this. This is like putting a puzzle together. If I don't have all the pieces, I can't put the puzzle together. So you've got to train your clients how important that information is. It's like doing something blindly. We've mentioned so many issues, so many blind spots that we have to look out for. That's why your intake form is so important and why you have to have a deliberate meeting, because there's just a lot of information that we have to uncover as practitioners. So the more prepared, the more structured, and the more compassionate you are, the more successful you will be. And your clients will leave away feeling confident in the plan that they're going to put together. So.
I can't top that. Questions?
Question. You mentioned AI and Copilot. What's your query other than summarize the document? Do you have anything specific?
So I have a temp. Yeah, the question was, when you're using AI, Copilot in our situation to analyze and review documents, what's your query? How do you do it? I have a template that I've prepared that actually has our firm branding on it, and within it, it has the exact formatting of how I want that review to be prepared. And it has instructions in there of when you're reviewing these particular instruments, what information to look for and how to summarize it. It's not always perfect. You have to look at what's there. It gives you an idea. It helps you review the drafts or the existing documents. But usually you can go in and with a minute tweak, get it to where it's very helpful when you're going into that initial meeting. That's how we're doing it.
I don't know free advertisements, but do you guys have a software for your electronic intake forms that you use?
Oh man, you're touching my buttons. The question was, do we use software for intake? We do at our firm, and it's been incredible. We use Clio, Clio Grow, Clio Manage, Clio Draft. It's not perfect, but it is wonderful. When we send it to the client, when they set up a meeting, it tracks the meeting. It sends them reminders. It lets us know however we set it up, whether or not they have submitted information. If not, it will send them a follow-up to get on that questionnaire. The information that comes into our system, it's in our system. And after we meet with the client, we can input more information. And then when we set the file up, after we run the conflict check, all the information is in our practice management system. It's there. And we also use Clio Draft to prepare most all of our basic documents. It's there. A lot of it's information the client provided us. So if the name is misspelled, it's because the husband didn't know his kid's middle name, right? Got to watch it though. When you're meeting with those clients, certain things change. So you got to clean that information up. But it's been huge for us for capturing information. Also on the practice management side, if you're working with multiple attorneys, having the ability to automate tasking internally. When we set up a new file, we have automatic tasks set up for who's responsible for what, and it sets deadlines. If that task is accomplished, it pings the next person, hey, you're here to review this, or it's your job to pull the vesting deed on that. Then it goes back to the other party, which allows me and my team to look at everything. Where are we getting bottlenecked? Why is this particular attorney struggling at this area? Why are we having to push meetings 6 weeks out when really we want to, not push them out 3 to 4 weeks? It's been huge for us. I could go on for another hour just about the technology.
Any other questions? Yeah.
I have one thing on the wealth side that we'll often tell our clients is, hey, we'll help you fill out the intake questionnaire, because that's usually a barrier for them actually doing what they need to do.
Yeah.
And usually that's us, filling in family details, showing all their accounts or any trust they already have. On your side of the table, do you have any concern with that? Obviously, you're still going to meet with the client in a confidential setting and confirm all of that.
I actually think that's great, because you're right. One of the things in the presentation that I hoped to get across was disarm the client about the intake form. Hey, this looks like a big deal, but it's really not. I think it's great. I actually say, get your advisors to help you. And that's why I have that on the intake form. Can I talk to your insurance agent? Can I talk to your CPA? Can I talk to your wealth advisor? I would absolutely tell clients, encourage them, work with your advisor. They'll help you create that financial statement. So I think that's wonderful. And I would encourage all wealth advisors to probably, offer that. And obviously you're going to give it to them to proof and review. You're not the one signing it, right? You're just helping them prepare it. So I think that's wonderful.
Yeah, agreed. And yeah, we want to help facilitate what we can for you guys. So we don't require you fill out our form or our intake questionnaire. Whatever format you use, we're going to roll with that. The more info, the better.
I'm okay with the financial statement too. I have my form created where you can fill out the first 2 pages and then give me a financial statement, but then I also have those other pages. If they don't have a financial statement, it's easy for them to just plug in.